Mais obrigado. Bom dia a todos e todas. Good morning to everyone. I'm Martin. I'm a doctorate candidate here in the program of our law school. And today we will have the third lecture of Professor Brian Bix on the problems on truth in law. And we're really happy to have you here and to end this another series on law and justice dialogues, organized mainly by Ariel Pesso, doctor and postdoctorate here at the program too, and Professor José Reinaldo de Lima Lopes, my supervisor. And Professor Brian Bix is the Frederick W. Thomas Professor on Minnesota Law School, University of Minnesota. He has taught jurisprudence, family law, contracts, had a lot of writings in matters of philosophy, legal theory. Has a published book on Wittgenstein in legal determinacy. And this is the matter he will speak about today. Afterwards, we have...
No worries, very little Wittgenstein.
Yeah? Okay. Yeah, the legal determinacy part, I think. And we have also Professor Ronaldo Porto Macedo Jr., which is the full professor of legal philosophy and legal theory here at our law school, and is the head of department currently. And Professor Clarissa Peterman Gross, which is law professor at Fundação Getúlio Vargas Law School here in São Paulo, and has also got her doctorate degree here at our law school. So thank you very much again, Professor Bix. The floor is yours.
First, let me thank once again the wonderful hosts, and those who've organized the trip, and all the faculty and students who have been wonderful, hospitable hosts to me during my stay. It's been a great intellectual experience. I hope it's better today than it was on Wednesday and Monday. We'll keep trying. We'll keep trying till we get it right, and very little Wittgenstein. So, but I want to speak today about some of the complexities and perhaps paradoxes of truth in law, complexities that are particularly significant in common law legal systems like those of the United States and England, but which are also present in civil law legal systems. In what follows, I will offer first a few quite basic observations, which I hope are uncontroversial, about truth in general. And then I will discuss why the application within and about the law creates special problems. Truth is one of those simple and common notions that philosophers can argue about endlessly, but which most people, at least those not corrupted by philosophy courses, seem to understand perfectly well and seem able to use on a daily basis without difficulty or misunderstanding, and even without the assistance of professional theorists. We say to one another, it's raining outside, and we understand, or think we do, what it is in the world that would make that statement true or false. Among philosophers, though, as noted, there can be fierce disagreements. Some commentators try to explain truth in terms of correspondence, that a descriptive statement or propositions are true if they correspond in some way to the way the world actually is. Other philosophers argue the truth of propositions should be evaluated according to the extent to which these propositions cohere with other propositions. And still other theorists, perhaps a little critically or a little cynically, argue for a deflationary understanding of truth, asserting that regarding a proposition P, that P is true, is no different than simply asserting P. These and yet other approaches vie for being the correct theory of truth for general propositions. However, our current concern is not on the nuances of the philosophical debates about truth generally. As we will see, truth claims within and about law are distinctive, and one's view about truth in law may not derive, at least not in any simple way, from one's preferred general approach to truth for conventional propositions. I assume that most of the people here and those listening online are law students or law professors. In either case, you are accustomed to making confident declarations of what the law is. That is, what the law is on some matter in your home jurisdiction at the present time. If you're speaking to someone not legally trained, after making your pronouncements, that person might ask, is that true? And you would answer even more emphatically, yes, it is. In this way, the truth of legal propositions within law or about law seem on the surface no different than assessing and asserting the truth or falsity of normal empirical propositions. Just as one says the cat is on the table is true if and only if the cat is in fact on the table, surely one would say a valid will requires 2 witnesses in the state of California is true if and only if a valid will in that state in fact requires 2 witnesses. So what's the difficulty? Ronald Dworkin wrote, "What are propositions of law really about? What in the world would make them true or false?" End of quote. In offering this and similar comments, Dworkin is not pretending to be naive or stupid. In fact, he had studied at a very good American law school, as well as studying earlier at Oxford University on a Rhodes Scholarship. He later worked as a judicial clerk for a well-known American federal appellate court judge, and after that worked for several years at a prominent New York law firm. He was clearly very able in doctrinal law and legal science, not just in abstract legal theory. When he says that it is in fact hard to state clearly what it is that makes legal propositions true, he is speaking from expertise as a lawyer. And if his comments strike many of us as strange, at least on first reading, it is because we are frequently less aware than we might be of how much analysis and what kind of analysis goes into our sometimes instant claims of the law of our jurisdiction, how the law of our jurisdiction would apply to some real or hypothetical set of facts. To be sure, sometimes determining what the law is on some matter at least seems to be straightforward. When you ask for proof that 2 witnesses are needed for a valid will in the state of California, I can point to a state statute whose text declares the will shall be witnessed by at least 2 persons. However, as an experienced lawyer, you would still be cautious. In a common law jurisdiction like the United States, one would need to make sure that a court decision had not invalidated or modified the statute. Perhaps there was some procedural problem with how the statute had been passed, or there's a possible conflict with a restriction imposed by the state or the federal constitution, and so on. Also, there might be some other statutes whose content overlapped or conflicted with the statute in question, at least when applied to certain fact situations. And the courts might have needed to modify one or more of the statutes to make them consistent. For example, in some states, there are separate statutes allowing, in certain circumstances, a handwritten, so-called holographic will to be valid despite the absence of witnesses. In any event, much of the time, when one is considering a question of what is legally authorized or prohibited, or what the extent of civil or criminal liability would be for certain actions, there is not any statute or constitutional provision or case decision that is, as we say, directly on point. What we learn in law school and what we begin to perfect in legal practice is a method of coming to legal answers through a combination of more or less expansive interpretations of legal text, uses of analogies, a reference to a variety of legal sources, all brought together as predictions of how officials will act, based in part on past observations. When a persuasive doctrinal argument is brought together from disparate texts and sources, it almost has a certain kind of aesthetic beauty, but that's to take us away from the point. The point to be emphasized initially is that legal truth is rarely a matter of simple correspondence or anything similar. It is usually not a matter of simply pointing, the way one might point to a cat sitting on a table to show the truth of the statement, the cat is sitting on the table. It is rather at best a bringing together of all the authoritative texts and decisions and principles that are relevant in a complicated calculation that students of law and even practitioners and judges take years fully to master if they ever do. Already one gets a hint of some of the complications for the truth of propositions of law. That whether A has a right to do Y, whether F has a duty to G, will be true or false based not on a simple correspondence, but rather based on a complicated line of reasoning with which reasonable and competent practitioners can, and in many cases will, disagree. But there is more, much more, as I will explain. Let us return to some foundational aspects of law, basic points, both in their importance and their simplicity. How do we get new legal rules? Perhaps the most common way involves legislatures enacting statutes. Statutes add to the list of valid legal rules and may also, either expressly or implicitly, modify or repeal some current legal rules. This also reminds us that when considering propositions regarding what rules are valid legal rules in this jurisdiction, the claims are expressly or implicitly relative to a particular point in time. For example, it may be the case that norm A is a valid rule in our legal system, was true a year ago, but it may no longer be true because of a law recently passed by the legislature. Another way that law changes, at least in common law legal systems, is by court decision. Courts resolve the disputes that are brought before them. In common law legal systems, and what follows is not true, or at least less true for most civil law countries, the resolution of particular disputes also changes the existing law. This change may be an alteration of how some authoritative text, like a statute or constitutional provision, is interpreted, or it may be an alteration of that part of the law, in common law countries called simply the common law, that is entirely judge-made. Generally speaking, much of contract law, accident law, and property law, parts of the criminal law are judge-made in this way. Like legislation, court decisions may simply add new legal rules to the law, or may change existing rules by modifying or overruling them. With both legislation and common law court decisions, the law is the result of choices made by legal officials. But with court decisions, both common law decisions in common law countries, and the decisions of statutory and constitutional interpretation in all countries, the judges generally purport to be declaring what the law already is. The implication of these decisions is that there is a right answer regarding the question of interpretation or application of the law. Judges and their opinions always give the appearance of confidence and certainty, whether they feel that way or not. But importantly, however confident judges may appear to be in their decisions, and however confident the judges in fact are, they will sometimes be mistaken. They will sometimes think that precedent requires one outcome in a case, when in fact the best understanding requires the opposite outcome. And the judges will sometimes think that the right understanding of a statute requires that it does apply to the facts of a particular case, but in fact the best understanding is that the statute does not apply, and so on. Let me pause here for a moment to note a potential complication, one we will return to later. To say that judges might have been wrong in their application of precedent or their interpretation of a statute is to assume that we can speak about right and wrong answers here, at least tentatively, independent of what the judges will ultimately decide. When the great American judge and commentator Oliver Wendell Holmes wrote that judge is just a prediction of what the courts will do in fact, though this may be an exaggeration, it does remind us that there is a close connection between what the law is and what the courts do. At the same time, it's clear that we must take it as possible to speak about right answers separate from particular court decisions. After all, if there was no possibility of being able to speak about individuals sometimes being wrong in their decisions, then we would not make sense of some basic aspects of legal life. Most obviously and prominently, the ideal of appealing a decision to a higher court depends on being able to make sense of the claim that the lower court was wrong. And the idea of a court's potentially having been mistaken in its interpretation of a statute or its application of past court decisions is also a basic assumption behind a court's decision, among those courts that have this power, to overrule earlier decisions by the same court. Excuse me. When this happens, when the court overrules a prior decision, it's generally not merely a matter of the court deciding to go in a different direction, as a legislature might. But the court's conclusion and reasoning usually is built around the claim that the prior decision was incorrect even at the time it was decided. One more point, though this may be the least important of all, the way most law professors teach law assumes that judges can be mistaken. It's a common practice, certainly in my country, for law professors to criticize particular decisions, whether relatively unimportant decisions about whether a contract was breached, or very significant decisions from the highest court about the powers of government. Criticize these decisions as having been mistaken. This is not merely a claim of the sort, I prefer to watch ballet while you prefer to watch football, each to their own taste. Rather, the claim is that there was an objective right answer to find, and the court allegedly failed to find it. So an essential starting point for this analysis, and one which should not be controversial, though occasionally a few might resist it, is that court decisions can be wrong, and that they at least occasionally are wrong. I then want to focus on the time periods before and after just such a wrong decision. Consider a potential wrong decision applying statute X to facts A, B, and C, determining erroneously that the statute does not apply under those facts. Before the decision was made, when individuals consulted with very good lawyers about the statute's application to situations with facts A, B, and C, those very good lawyers would have said, correctly applying the jurisdiction's principles of statutory interpretation to the enactment, that the statute does apply to those facts. The very good lawyers would state confidently that this is just what the law is, this reminding us that when we speak about the law in our jurisdiction as including not only the words of the statute, but also the interpretation that follows from the accepted rules and principles of interpretation. Doctrinal reasoning, legal science, according to the phrase used in your community. Now, what will happen when we speak to those same very good lawyers after the judge comes down with a decision applying the statute in a way contrary to what those lawyers have said was the right way to interpret the statute? That is, after the judge's wrong decision. And for a moment, let's assume the judge in question is at the bottom rung of the judicial hierarchy. In the American legal system, in both the federal court system and the court system of most states, the trial court judge is at the low rung, and above that level in the federal system in almost all states is an intermediate appellate court, and above that, the highest court, also known as the state Supreme Court. The clients will probably return to their very good lawyers and want some explanations. The client would say, you stated that the statute does apply to these facts, but we have now learned that a trial court judge has decided precisely the opposite way. The lawyers will respond that they still think that their earlier statement about the statute was correct, and they might add, with varying levels of confidence, depending on what they know about the judges and the local practices, they might add that they expect the judge's mistaken decision to be corrected, to be overturned on appeal. However, these very same very good lawyers, because they are very good lawyers, will likely add that there is a chance, and how big a chance, depending on local judges and practices, that the incorrect decision will not be overturned. The matter might never get reviewed at all, or the appellate court might even affirm the lower court's mistaken decision. So if pressed by their original clients, or perhaps if approached by new clients after the court decision, and the clients are asking about the application of the statute, the very good lawyers will now hesitate, and they will now hedge the answers they give. They will say that on the one hand, they still think the statute does apply, but that on the other hand, the judge has now decided otherwise, and there's a chance that this decision, wrong as the very good lawyers think it is, will be allowed to stand. Now let's push forward in time and consider a scenario where that judicial decision, considered wrong by all the very good lawyers, is nonetheless affirmed by the appellate courts, including the highest court in the jurisdiction. Now, when clients approach the very good lawyers and ask them about the statutes, the lawyers will comment the courts have said that the statute means one thing, even when all the very good lawyers knew, or at least once knew, that the statute meant something different. And the very good lawyers will give advice in line with the judicial decision, not in line with their own prior views. The shorthand that the law is what the courts say it is works for many and perhaps most purposes. And now let's move even further ahead in time. The decision that very good lawyers considered incorrect has not only been affirmed, it's now well established and frequently cited by courts and commentators. Yet very good lawyers and some law professors still believe it's not the best understanding of the statute it purports to apply. Here I'd like to bring in Connie Rosati's discussion in connection with the notorious American Supreme Court case, Plessy v. Ferguson. In that case, way back in 1896, the Supreme Court decided that facilities that were racially segregated could still be consistent with the Equal Protection Clause of the 14th Amendment to the United States Constitution. It is a decision that is now universally considered to have been badly wrong, but it remained the settled law of the United States for almost 60 years. Rosati comments, quoting here, "It is a puzzling feature of our legal practices that we can intelligibly say the law is Plessy, but Plessy was wrongly decided," end of quote. This already has the sound of paradox, perhaps like the paradox of propositions and belief. The cat is on the table, but I don't believe it. Rosati, in fact, presses the paradoxical nature of that claim. She writes, quoting again, "To say that the law is Plessy, but Plessy was wrongly decided, is thus to say that the law is and is not Plessy. There is a sense that that's the end of the quote. There is a sense that the wrongly decided case, whether a notorious case of important constitutional interpretation or a more modest case of the application of a statute to a recurring set of facts, creates a circumstance in law contrary to the standard rules of logic, that a proposition, here Plessy is good law at this point in time, and its opposite, Plessy is not the law, seem both to be true at the same time. Let us retrace our steps and see how we got here. In most legal systems, even those without court-made common law rules, there are distinct authoritative sources in the law, which usually reinforce one another, so we know how to resolve conflicts. In the United States, legislation has priority over judge-made common law rules. Federal statutes have priority over state statutes, and the federal Constitution has priority over federal statutes. However, there are other conflicts which are more subtle and whose resolution is a little more complicated. For example, a statute is an authority within a legal system, as is the court's interpretation of that statute. And when one believes that the court's interpretation of a statute is mistaken, then there is, in a sense, a conflict between the statute and how the court interpreted it. In most jurisdictions, the court's interpretation basically takes priority. It states the law in case of a conflict, though this is not the whole story. One might say, in a case of mistaken interpretation of a statute, that the statute once meant A has changed. It's been changed by the courts and now means B. However, matters, though seemingly settled regarding this change of meaning, may not be settled forever. In most jurisdictions, at least in the United States, some courts, including usually the highest appellate court, have the authority to change their minds on legal matters. Generally, there are both principled and pragmatic reasons for why such powers are and should be used only sparingly. But those powers generally are used. By one count, the United States Supreme Court has expressly reversed itself 146 times. So this is out of over 25,000 decisions. And this does not include the far more frequent occasions when the court majority claims to be following precedent while dissenting justices and some commentators argue the majority is in fact mischaracterizing precedent and has in fact effectively, if secretly, overturned prior law. Perhaps the most famous recent example of the U.S. Supreme Court overturning prior law is the 2022 decision overruling an earlier decision on the issue of the constitutional right to abortion. The earlier case had held that the federal Constitution does protect a woman's right to obtain an abortion, while the recent decision held that the Constitution does not protect that right. One reason that the court's overruling its own prior decisions is even conceptually possible is that while there is a sense, as already discussed, that the court's interpretation of an authoritative text, a statute or a constitutional provision, is the law, even when that interpretation arguably conflicts with the text it purports to interpret, Even though all of this is the case, the legal text, the statute or constitutional provision, retains its authoritative status. So a later court can refer to the legal text as a justification for rejecting the earlier interpretation. And that later court can claim that the earlier interpretation was wrong and that it had always been wrong. When the United States Supreme Court in 2003 in Lawrence versus Texas overruled a 1986 decision, Bowers v. Hardwick, on whether it was constitutionally permitted to criminalize homosexual sodomy, the earlier case said yes, the later case said no. The court stated, here I'm quoting, Bowers, that is the earlier case, was not correct when it was decided, and it is not correct today. End of quote. However settled a case might seem within a legal system, and this is true whether the case was in the general view correctly decided or incorrectly decided, it is always possible, at least in jurisdictions that allow courts to overrule themselves, for that settled law to be upended. Part of the dynamic underlying the problem about truth and law I am discussing today is that no law is entirely settled once and for all. Statutes can be revised and interpretations can be changed. This might be a good place to note a matter that is obvious, but not often enough made prominent in these sorts of discussions. That which decisions are mistaken and which ones are clearly or egregiously mistaken. Such judgments are themselves often highly controversial. While it would be very hard to find a reasonable judge or academic in the United States today who would defend the pro-racial segregation decision Plessy versus Ferguson, reasonable academics and judges are far more divided on whether it was the recent anti-abortion rights decision Dobbs or the pro-abortion rights decision of 50 years ago, Roe versus Wade, that was clearly mistaken. And such controversies complicate the analysis. Some people might be tempted by the idea that clearly wrong decisions never really become law, just as some are tempted by the slogan associated with some natural law theories that an unjust law is no law at all. But this view loses any attractiveness it might have had when one recognizes that there will rarely be a consensus about which decisions are clearly wrong. Returning to the argument, what courts and commentators do agree on is that judges sometimes make mistakes, even if they disagree on which decisions are the mistaken ones. And judges and very good lawyers and law professors and very good law students also all know that a legal system has a variety of authoritative sources, what a philosopher might call different truth makers of propositions of law, and that these sources of authority can sometimes conflict, creating complications about the truth in law. There are two important topics in law and legal theory with which the present discussion of truth and law might seem to be connected or at least overlap. They are defeasibility and indeterminacy, not Wittgenstein. Each of these are intricate, difficult topics in which there is a large literature. And while I have in my very few minutes here, can offer only a sketch, but I do want to clarify some of the differences between those topics and what I'm talking about today. Defeasibility defines a group of related types of reasoning and logic, and some commentators, prominently H.L.A. Hart in one of his earliest publications, have argued that defeasibility was distinctive of legal reasoning. Excuse me. Hart was thinking of situations where some evidence is sufficient to justify a legal conclusion, but if certain additional information came in later, the conclusion would be reversed, in a sense, defeated. Think of contract law. Under American rules, if I can show that there was an offer, acceptance, and consideration connected with an agreement, this would be sufficient for a court to conclude that a valid and enforceable contract existed. If no other evidence was introduced, that would be the legal conclusion of the case. However, there is evidence the other party might introduce, evidence that in no way contradicts the evidence of offer, acceptance, and consideration, that could defeat the claim. For example, evidence of fraud or duress or the absence of a required writing. Evidence of that sort would be sufficient to ground a court's conclusion that there was no valid contract, even though offer, acceptance, and consideration had been present. Thus, the feasibility, at least of this type, does involve the changing of the truth of the proposition based on additional evidence on other matters. The truth of the proposition there is a valid contract between me and her changes as and when that other evidence comes in. And this is not a simple matter of the law changing because the legislature has added additional enactments. The world has not changed. It's simply that additional facts have been revealed, facts of a different sort that cause us to change our conclusions. But unlike the Plessy discussion above, it is not the case under the feasibility examples that at any one point there is a valid contract between me and her is both true and not true at the same time. The debates about legal determinacy and indeterminacy, which were more vibrant a few decades back, but which have not entirely disappeared, were, like the present discussion, sometimes couched in terms of legal truth. Claims of legal determinacy, like Ronald Dworkin's right answer thesis, could be characterized as a claim that all propositions of what the law is, as regards some dispute being heard by a court, are either true or false. Some claims of legal indeterminacy in turn would best be understood that certain propositions of what the law is, relating to especially hard cases, were neither true or false. The issue of legal determinacy ranges across a number of subtopics, but the main focus is whether there were right answers to all or even most legal disputes. And the question was often made more precise by a clarification of whether any right answer derived from the legal materials on their own, rather than, say, from the judge's shared political and social biases. Some theorists who argued for widespread legal indeterminacy made clear that their view was consistent with pervasive predictability of outcomes. Their argument was only that the predictability of outcomes derived from social and political forces and biases and not from the legal materials themselves. As mentioned, debates about legal determinacy and indeterminacy often turned on claims that for particular legal disputes, in particular the hard cases that are fought up to the highest courts of the jurisdiction, there is no truth regarding the outcome, at least before the decision is rendered. One can thus see the contrast between advocates of legal indeterminacy and the present discussion as follows. For some advocates of legal indeterminacy, for many, perhaps most hard legal questions, the proposition of what the law is neither true nor false. While in the present discussion, the proposition of what the law is, for example, right after Plessy was decided, the proposition Plessy is good law, that proposition is both true and not true. Under Mark Tushnetz's distinctive view, legal indeterminacy is a function of time combined with the resources of advocacy groups and their elite lawyers and commentators. Such litigation, lobbying, and scholarly advocacy can make arguments acceptable that had earlier been dismissed as ridiculous, and eventually can even make legally true what had been legally false, this change occurring without any action by the legislature. Thus, in the United States, even recently, a constitutional amendment that had once been treated as offering no protection to individual gun owners now is held to give individuals significant rights to own and carry those weapons. And on the other side of the political spectrum, an amendment that was once held to offer no protection to same-sex couples has now been held to require states to include same-sex couples in their marriage statutes. What was legally false before has become legally true, and the opposite, again, without any action by traditional lawmakers. By way of conclusion, most legal systems recognize authoritative legal rules based both on some version of reason and some version of choice. Reason is legal reasoning, doctrinal reasoning. Will is fiat, the choices made by lawmakers amongst available options, including choices made by judicial lawmakers. Because law is the product of both reason and will, there will always be the potential, greater in some legal system than others, that the two criteria will conflict, leading to uncertainty in what the legal truth on some matter lies, including the possibility that contradictory propositions about the law will have equally, or at least comparably strong claims to be correct. In a way, this may just reflect an even more general truth about law mentioned earlier, that legal norms and norms about law within a particular system may conflict, and the legal system might or might not have the resources to offer quick or widely accepted methods of resolving those conflicts. From time to time, more than one legal norm may apply to a set of facts, and occasionally those legal norms are not merely in tension, they may contradict one another. What can we take from all of this? The present work is not offering any general claims, and certainly no general revolutionary claims about the nature of truth. Truth in law in particular, it's woven into the practice of law, and it is the practice which grounds the somewhat paradoxical claims of the present work. I would not here call those claims unconventional, as it is only saying something that experienced practitioners, theorists, and very good law students already know at some level, even if they're not always conscious of it. Because of the conflicting sources of authority, truth in law is, in small ways, on the margins or in the background, unstable and unsettled, or at least subject to being unsettled. It can be the case that, to take our earlier example, that Plessy v. Ferguson both is and is not valid law. Thank you.
Thank you very much, Professor Bix, for this really interesting conference. I now pass the word to Professor Clarissa.
Good morning, everyone. Thank you, Professor Bix, for this very enjoyable lecture. I'll try to do my best to offer some interesting comments. I want, first of all, to thank Professor José Reinaldo and Ariel for the invitation and the opportunity to take part in the seminar, and also express my gratitude to Professor Bix for being here, and all the organizers of the seminar for their efforts in making this and the other discussions that took place this week possible. I would also like to greet Professor Ronaldo, with whom I have the pleasure of sharing this discussion. So my comment on Professor Bix's text will be brief. I believe it addresses and questions what seems to be one of the central arguments of the text, namely the observation that certain legal situations lead to paradoxical propositions about and within the law. Professor Bix's work is particularly interesting as it sheds light on various contexts in which we ask the question, what is the law, and strive to answer it. In my view, one of Professor Bix's main arguments is that in certain legal situations, we respond paradoxically to the question, what is the law, by affirming both that the same action guiding rule is the law in a particular jurisdiction at a particular time, and that it is not the law in that same jurisdiction in that same time. One of the examples mentioned by Professor Bix is the US Supreme Court's decision in Plessy versus Ferguson, which deemed racial segregation practices compatible with the 14th Amendment to the US Constitution. Regarding this decision, Bix cites Rosati, who states that it was true to say both that during the time when the Plessy decision was in effect, the Plessy precedent was the law in the US and that the Plessy case had been wrongly decided. According to Bix, simultaneously affirming that Plessy was the law in the US and that it had been decided incorrectly was equivalent to saying that Plessy both was and was not the law in the US. Therefore, the simultaneous statements would constitute a paradox. In my view, it is possible that the simultaneity of these statements constitutes only an apparent paradox. This happens because, in my view, each of the statements answers a different question, even if these different questions are formulated in the same language. To clarify my point, I would like to advance the idea that the question, what is the law, does not mean the same thing in every context in which it is asked. In other words, depending on the context, when we ask what is the law, we may be seeking answers to different problems. The example developed by Bix helps to illustrate this point. It is the example of highly skilled lawyers being asked whether a particular law applies to the set of facts A, B, and C. A person who asks a lawyer what is the law may be seeking answers to very different problems. In many cases, the person wants to know what the established understanding of the law enforcement authority is regarding the rules applicable to a set of facts. The point, therefore, is about predicting the likely position of the authorities on what the law is. However, a person may be seeking something else. The person may be seeking the correct understanding of what the law is. Professor Bix himself states that a widely shared assumption is that the criterion of truth regarding what the law is does not correspond solely to what the authorities decide about what the law is. Hence, we share the assumption that judges sometimes make mistakes. If this is the case, unlike the person who asks what the law is in order to access the established position of judges, a person may be interested in accessing the position of an experienced jurist on what the law is according to the most sincere, sophisticated, and thoughtful interpretation of legal sources made by that jurist. From these observations, we can conclude that one way to understand the statement that in the US at a certain time Plessy both was and was not the law is to recognize that each part of this statement responds to a different meaning of the question, what is the law? The statement that Plessy was the law answers the question about was the established position of the authorities on the compatibility between segregation practices and the US Constitution. The statement that Plessy was not the law, on the other hand, answers the question about the correct way to interpret the US Constitution, knowing that this standard of correctness does not correspond simply to what the judges say about the law. There is also at least one more meaning to the question, what is the law? A person may be asking not simply what the judge's position is, nor simply what is the most correct interpretation of the law, but what her moral prerogative or duty is in a particular situation. In other words, when asking what is the law, the person may be asking about what their prerogative or obligation is before society in a given situation. Perhaps this possible meaning of the question is what sometimes collapses the two other meanings pointed out above and gives certain contexts an appearance of paradox. When we ask what our duty before society is, we have the intuition that both what the judges decide about the law and the independently correct understanding of the law according to applicable truth criteria, which do not correspond merely to the judge's position, are relevant in determining our duty. Sometimes it seems that the judge's position is more relevant than the independently correct understanding of the law. Other times, the priority relationship is reversed. For example, it is possible that many people disagree with a certain understanding established among judges regarding property lease laws. Although many people may think that the judge's understanding is blatantly contrary to the literal wording of the law, or that this understanding makes the law in general very inconsistent, it is likely that many people insist on their duty and that of others to behave according to the judge's position. This is because even though the judge's position may make the law less legitimate, the part of the law incorrectly understood by the judge is not so central to ensuring the overall legitimacy of the legal system. Thus, respecting the judge's decisions would constitute a more important duty in this context and would be more relevant to safeguarding the general legitimacy of the legal system. But it is possible that the primacy of respect for the judge's position does not hold in all cases. The issue of racial segregation in the US may be perhaps an exemplary case in which disobedience to the prevailing position of the judges was more important for the legitimacy of the legal system, and therefore more relevant to answering the question about the moral right or duty of individuals. In this case, the correct interpretation of the law prevails over the judge's understanding in defining the moral rights and duties of individuals. The fact that both the authorities' decisions and the best interpretation of the law are aspects of legal practice that can legitimately claim our deference is briefly noted in the conclusion of Bick's work, where the author asserts that both will and reason are sources of authority in law. This paragraph in the conclusion of the text might suggest that the sense of the question, what is the law, that permeates the work is the one inquiring about the moral duties or rights of individuals in a particular legal situation within a specific jurisdiction. However, in my view, the sense of paradox that certain legal situations may evoke by presenting a conflict between the demands of the authorities' decisions and the best interpretation of the law would merely be a lack of more sophisticated theorization about the relationship between these two aspects of law in different social and legal contexts. Therefore, we may be lacking more sophisticated and complex theories about the relationship between legitimate moral demands, the judge's position, and the correct interpretations of the law. Such theories would provide the minimal conditions of legitimacy for the exercise of state power, which would probably involve pointing out the problems and issues for which the position of the authorities is more or less relevant. However, such a theory would not lose sight of the different senses in which the question, what is the law, can be asked. If we do not lose sight of the different meanings of this question, the possibility increases that simultaneous statements that a certain rule is and is not the law are only apparently paradoxical. Well, I want to conclude my contribution here. Once again, thanking Professor Bix and all the organizers for the opportunity of taking part in this discussion, and looking forward for our conversation that will certainly follow. Thank you very much.
Thank you. And I'm reminded I need to give a more general thank you as well. I'm grateful to all of you, both commentators and the audience, to indulge, as you indulge all the time, we poorly educated Americans and Britons who have no skills in foreign languages, and you allow us to come to your country and present and discuss in English. I'm afraid if you came to my country and tried to give a talk in Portuguese, it would be difficult. So I understand the indulgence, and I'm grateful. And I'm equally grateful that important scholars are taking time from busy schedules to engage with my work, and I'm duly humbled by it. So just a few comments. I mean, the last part of the commentary on the connection between what judges say and what the law says and what our moral and social obligations are is a vast topic, which I will leave to others. I have views, but that's for another time. Let me respond mostly to the first part. So it's certainly the case that there are lots of different questions and lots of different contexts, right? So let's take our very good lawyer, who's a very good lawyer who deals both at the trial court and appellate court level. And after the wrong decisions about the statutory interpretation have become settled law, and a client says, does the statute apply? If the lawyer gives the answer she thinks is really the right understanding of the statute, different from what the courts have decided, if she gives that answer to the client, she is doing what we call in my country legal malpractice and can be sued. It's wrong. It's the wrong thing. It's wrong advice. It's bad advice, and it's legally inappropriate. On the other hand, once the case about the statute's application goes to the trial court, goes to the appellate court, each of them, intermediate appellate court, each of them applying the settled rule that the state, that the highest court has affirmed. If it's then appealed to the highest court, it's then open to the lawyer. It's no longer legal malpractice to say the statute means something other than the settled law. It is an available legal conclusion before the highest court to try to persuade them to change their mind, and you persuade them to change their mind by saying that the statute means something different than what you've been saying it means, and it's always meant something, right? So, Oliver Wendell Holmes's famous article, "The Path of the Law," was about trying to convince law students that when they become lawyers, they should focus on your advice to a client, and your advice to the client depends on context, right? But you say there's a difference between the lawyer giving advice and we mandarins, as we might be called, we aloof law professors saying what the law really is. But I think that still understates the paradox attention that's still there. And I may mention earlier this week, one of my favorite articles, Sanford Levinson's Law of Literature, where Levinson comments, that he, like me, like many people who teach constitutional law in the United States, most of us are somewhat left of center to varying degrees, and most of us spend a lot of our time telling the students, what the court said 40 years ago was a mistake, and what the court said 30 years was a mistake, and what the court said 10 years ago mistaken, what the court said last year was really mistaken. They keep getting it wrong, right? And Levinson says, that's what all of us do, is all of us talk about, there's the court and there's what the Constitution really means, right? But Levinson goes on in that article to say, but there's something conceptually off about that, because we live in a system where, you know, there's a metaphor in the legal theoretical literature between whether you have a Protestant approach to truth or a Catholic approach to truth, where a Protestant approach is like the idea that everyone has an equally legitimate claim to make a statement of what the law requires, let's say. And this view is often equated with Ronald Dworkin, who's often called, and one of his articles admitted that he sort of took a Protestant approach. But Levinson says, we don't. We live in a Catholic system where there is the equivalent of a pope who says what the law is, you know, the law, in a sense, the law is what a settled majority of the U.S. law is what the settled majority of the U.S. Supreme Court says it is. So when we say that the court is wrong, and it's been wrong for a very long time, that is basically conceptually incoherent. Because you know, I mentioned in my talk Monday, there's an approach to morality called the divine command theory. Morality simply is what God commands. Whatever God commands is what's morally required. What's morally required is whatever God has commanded, period, right? There is a sense that the law is what the settled majority of the U.S. Supreme Court says it is. So in a sense, when we say, you know, pussy's not really the law because they got it wrong, in one sense, that's incoherent, but not entirely incoherent, because the court may eventually, in 1956 or whatever it was, come down with Brown versus Board of Education. Bowers v. Hardwick will be overturned by Lawrence v. Texas. Roe versus Wade was overturned 50 years later, and maybe that decision will in turn be overturned 20 years from now. So it is and is not coherent for the law professor mandarins to say, let me tell you what the law really is. So it's not wrong. I mean, Levinson is a little bit off. It's not entirely wrong, because there is this possibility that the court will come to its senses. Randy Barnett is a wonderful libertarian constitutional theorist and contract law theorist. You know, he writes books that talk about what other people describe as the Constitution in exile. His view is that from the notorious case of Lochner versus New York, you know, that whole era, that case, he believes, unlike every, 98% of law professors, he believes that was rightly decided, that the Constitution, in fact, enacts a libertarian view. And he's waiting and arguing for someday, a majority of the Supreme Court to come around to the truth. Right? And it's not, it's fanciful, but it's not entirely nuts. It's only 90% nuts, right? Right? And that's the paradox, that even if we move away from the context of the client asking the lawyer what is the law is at the trial court, what is the law at the trial court, even if we're talking about our mandarins, we're talking about, well, what really is the law? Right? I don't think that paradox ever quite goes away, regardless of how you phrase it or what context you put it in. At least in a system like the United States, where on one hand, the law is what the majority of the court says it is, and on the other hand, the court can change its mind. And it doesn't matter if it's been 5 years or 60 years, the court can change its mind. And when it changes its mind, it will say, this is what the truth has been all along. Not we're going in a different direction, or society has changed, but this is what the Constitution meant.
Thank you, Professor Clarissa, Professor Bix, Professor Ronaldo. The floor is yours. Do you want to comment on that?
I could do that, but
Yeah.
I'm a bit worried about our time. I don't know if maybe we leave it for the
Maybe for the discussion.
the discussion.
Yeah, okay.
Yeah.
Okay, then Professor Ronaldo, please.
Well, yeah. Well, I'd like to to thank you for the kind invitation and the organizers. It's always important to stress this. It's a hard work to organize all this, and it's really a pleasure. It's a great opportunity for the University of São Paulo Law School to have you here, Professor Bix. So thank you, Martin, Ariel, José Reinaldo, and I hope I'm not missing anyone who really worked on this. It's really a pleasure to meet you again, Professor Bix. We met recently in the IVR meeting in Seoul. Well, there are many issues that have been raised in your paper. I'll just try not to list too many, even though I'd like to listen your comments about many of them that I know you won't have time. Yeah. Well, but I'd like just to stress some points that I became a little bit curious to know more about your thoughts. One of them is a footnote where you mentioned Mark Greenberg's ideas, which some related ways are close to Dworkin's positions. So I'd like to know why do you put this and what do you have in mind on that footnote that you expressly put aside from your main argument. But my general question, or if you allow me, provocation, is very much in line with what Clarissa said in terms of I'm in full agreement with many of the ideas that you presented and the development of these ideas, that there are many sources of law, that in many cases the revision of a decision in a way, at least apparently, shows a kind of paradox about what the law is and what is the correct interpretation of law is. You made a very clear and very elegant argument for this. However, the conclusion, it's a little bit puzzling for me. I mean, the conclusion, and I don't know how far you go on this conclusion. If it is a kind of rhetorical teasing when you say that the Plessy is law and is not law, because I'm very much in line with what Clarissa said, that it depends a lot on the concept of law that you're taking into consideration. But to say that it is a contradiction, that is a real paradox, it would be necessary that the meaning of law were stable, were the same. Otherwise, we could say simply that we could, in the Wittgensteinian jargon, solve the question. that we can simply dissolve the question. And in many moments, you seem to use a language that could be forcing the idea that there is a real paradox. For example, when you say, in many ways, you stress that there are many sources of legality. You use the word legality. But in other ways, in other moments, in other paragraphs of your article, you stresses that there might be a contradiction between the idea of validity, not of legality. And the idea of validity, in my perspective, is very much committed to a specific conception of law, which defines legality as a belonging to a system of established authoritative rules. So that's now Dworkin comes in. So that's one of the criticisms that Dworkin makes in an article published in the Justice in Robes about the misleading conception of validity, because it's so much embedded in the legal positivism premises that in a way put aside many of the legal sources of law, especially the moral sources of law. So in this sense, I fully agree and follow your argument that if you take the law as being what is written in the Constitution, for example, about abortion or about equality, and you take Plessy as a kind of rereading the same text, but let's say attaching to it a completely different meaning. I mean, if this is the law, of course, it's a clear contradiction between the two interpretations. However, if you take the law as not being what is authoritative established by rules, as for example, the political morality of a community as part of the sources of law, you may also acknowledge that the law has changed, not only, or in this case, not because the text of the Constitution has changed, there has been no literal change, but because the context in which we interpret the law has changed. So again, to invite Wittgenstein to our conversation once again, very much like the famous discussion Wittgenstein presents in the Philosophical Investigations, I think it's paragraph 186, famous one, when he describes a rule, mathematical rules that are in a way tells you to add number 2 to an ordering. So you say 2, 4, 6, 8, etc. But this rule, add 2, may be changed after, I don't know, number 1000, because it was not fully determined that you should follow the adding 2 until, I mean, ad infinitum, that you could maybe change the meaning of the rule because it was partially indeterminate if you take just the commandment of that rule, and it could, after 1000, you should add 3, or you should add 4, or something like this. Okay, so this led many scholars, as you know better than I do, to think that Wittgenstein was siding with the skeptics, some kind of a radical indeterminacy interpretation of how of the rules. However, in a very complex setting, in a very complex context, such as law, we usually have not only one rule that is indeterminate, but we have context. I mean, law is context dependent. Law is multiple sourced dependent. So in a way, if we transfer, or if we transport this kind of example, this Wittgensteinian example, to law, it's very unlikely that when we reach number 1000, we wouldn't know more about how to continue the sequence. So for this reason, for example, if Plessy was established in a moment where, well, the legal materials or the evidence of the legal materials were X, after 50 or 60 years, all the evidence might have changed. So we are not really applying the same law. So if we take this, I think we could dissolve the idea that there is a contradiction. Yeah, we could say simply that, well, this is a different context, which has a lot of similarities. One of the very basic similarities is that the Constitution writing is still the same, but many other factors, actions, practices have changed a lot. So in this sense, I think we could maybe dissolve the idea that there is a contradiction or a paradox. And I'd like just to add another sub-item to this challenge, which is something that H.L.A. Hart has stressed very convincingly when, and you mentioned this, I mean, the stability, or what I think he called definiteness of a decision, is not a synonym of the rightness of a decision. We usually use football example here in Brazil. This is one I like very much, especially because you want to use it to tease the Argentinians. In the 1978 World Cup, Maradona made a goal using his hands. La mano de Dios, God's hand. Yeah. Okay. So it was considered a valid goal. However, it's clear that that was an illegal practice. Even though, I mean, probably we won't anew the World Cup given to Argentina due to that. So in this sense, we can accept that sometimes, I mean, the permanence or the definiteness of a decision could come along with the idea that it was still wrong. So again, this is another argument that I think could be used for to address or to challenge some of your examples that led you to the conclusion that there is a real contradiction. And well, this is basically what I would like to stress and hear more. Thank you. Thank you very much for your presentation.
Thank you. Again, I'm honored and humbled by such prominent scholars engaging with my work. And of course, it's a matter of pride. I don't like to be out Wittgenstein by anyone, but I may have to allow it here. Just a few responses. I become, I guess it's because I'm old, I become repetitious. You wisely missed the talk on Monday, but Monday I brought up precisely Hart's argument. It's actually one of my favorites. The idea that, you know, while sports fans may say, you know, look, the referees are getting it all wrong, the umpires are getting it all wrong. A goal seems to be scored whenever they say it is. That seems to be the only rule, right? They said, you know, we could call, you know, if that really was a rule, he says we call that game scorer's discretion, where the only rule is a goal is scored when the referee says it is. He said that would be nonsensical, and it's not a fair description of what is actually going on. That judges, even referees, even incompetent ones, are purporting to, and usually trying to apply the rules. Judges, even incompetent, mistaken ones, are usually trying to apply the law. And I take part, you know, to be making my point, which is, you know, there's whether there actually was a goal and whether it was counted as a goal. And, you know, there's, you know, the way it works is, you know, even you can show as many replays as you want after the game's over, they're not going to give the World Cup to someone else. So apparently that does happen with bronze medals, but another issue. Can the Constitution mean one thing at one time and another thing at another time? Absolutely. In the U.S., the U.S. Supreme Court has accepted, for the purposes of the Eighth Amendment, which forbids cruel and unusual punishment, that the determination of cruel and unusual punishment can change due to circumstances, and that while, let's say, the execution of a minor or the execution of someone who is below a certain level of mental competence may have been acceptable in 1790, it's not acceptable now, and the court portrays this as the Eighth Amendment. The meaning of the Eighth Amendment, or at least its application, has changed. Fine, and there are, of course, prominent constitutional theorists, more outside the U.S. and inside the U.S., that argue that Constitution should always be interpreted this way. That Will Wallichow talks about the living tree Constitution. Other just talk about just living Constitution. That the meaning of the application of general terms and constitutional provisions is meant to change with different understandings of and different social norms. But the examples I had been giving, Plessy against Brown, Bowers v. Hardwick against Lawrence v. Texas, the court doesn't say, yeah, it used to be constitutionally okay to criminalize homosexual sexual acts, but Now it isn't. No, they said it was wrong before, it's wrong now. I mean, there are debates in moral philosophy. Well, slavery might have been okay in ancient Greece because, you know, it's a different life and a different time and different struggles, but not today. Right? Most of us don't take that view. Most of us take the view slavery is wrong now. It was wrong at the time before the American Civil War and was wrong in ancient Greece. Right? So, yeah, I understand you can make an argument that as society changes, social norms change, economic circumstances changes, the application of both moral and legal norms may change. But that's not what's going on in the cases I'm discussing. The case, at least the rhetoric of the cases I'm discussing, is not that the Constitution has changed on these issues, but the decision was wrong before, and it, you know, it has always been wrong, and now we're getting it right. Dworkin and Greenberg. Okay, I'm not sure. I mean, I think this, you know, I'm happy to book a ticket for my next trip, and we can do this because this is a big topic. I will grant you right now that if you are a hardcore Dworkinian, which some people say you are, or a hardcore Greenberg follower, this whole analysis, you need to put it aside. This analysis, the analysis I present, assumes a relatively conventional view. For example, that when a legislature enacts a statute, it adds the law, right? And that, you know, when a court makes a decision, that's a new law, and it adds to the valid legal rules of our system. Dworkin and Greenberg offer a radical view, and as I said, I don't think this is the time, you know, to evaluate them. But you know, for Dworkin, what the law is the product of an interpretation that takes into account all past actions by legal officials of your system. And additionally, as I mentioned in passing in response to earlier discussion, for Dworkin, the Supreme Court has no special authority. I mean, it's true that you need to take Supreme Court decisions into account, but there's no particular reason to believe that the Supreme Court, whether a majority or even a unanimous court, is the final answer or has more authority as to what the Constitution means than you or I do. And Greenberg goes a step further, and it's consistent, arguably, with some of Dworkin's ideas that he was sketching at the very end of his career, where Greenberg says the law is the effects on our moral requirements created by the actions of state officials. And these are very, I mean, Greenberg in particular, very radical rethinking of what most of us, not just law professors, but and law students, but average citizens of the streets, mean by the word law. And you know, part of my question when I wrote a brief critique of Greenberg is this entails a significant change in our practice. Why do you think this change is needed, and why do you think it's justified? Because much of what Greenberg says is, you know, can be seen also just as a transposition of entirely conventional ideas by people like Aquinas or John Finnis, where Aquinas and Finnis say, you know, sometimes what the legislature does creates new moral reasons for action, or as Aquinas says, binds in conscience, and sometimes it doesn't. Right? That's entirely conventional. But Greenberg goes further and says it's only the law. The law is, you know, those changes and only those changes of our moral norms. And you know, I said it's a big topic, and especially since I don't know how many people listening here or listening online, you know, are familiar with all of Greenberg's ideas. So I don't want to go down that route too much. But yeah, if the starting point is Dworkin or Greenberg, then yeah, the whole thing needs to be significantly rewritten.
Thank you.
Thank you, Professor Ronaldo, Professor Biggs again. So I guess we have a little time for some Q&A sections or little questions.
Also,
If you want to comment.
Yeah, sure. Well, Okay, so I want to follow Professor Bick's comment on what Professor Ronaldo asked, when Professor Ronaldo suggested that the law may change because of the context and the circumstances, and then Professor Bick says that, well, that may be true, but this is not what was implied in the examples that I mobilized in my text, because in the examples I mobilized, the court was not saying that the context changed and that's why the court is now decided differently. It was saying that the previous court was wrong all along, right? And I hear that that would be the quintessential example that would support your claim of the existence of a paradox. Yeah, because, and then, I mean, I want to unpack, what the paradox here would be. Because the court would be saying at the same time that the law in the US was Plessy and it was not Plessy all along, right?
Well, the Rosati statement, the law is and is not Plessy, is more pointed to a point of time right after a decision where it's, the dynamic is different than after it becomes settled law. But it is another example that I offer as to support. But I just want to make clear that's not Rosati's example. Rosati's example is right at the point where I'm mistaken. Forget about Plessy, the statute, right? And what does the statute apply to these sets of facts? The trial court says no, it doesn't. All the good lawyers say that's not right. There's a different set of uncertainty at that point. But
yeah, but my point would be, I mean, what does it exactly you mean by saying, or Rosati means by saying that not Plessy, but the other, because it doesn't have a name, right? The example of the statute applying to facts A, B, and C.
That when people talk about what the law is, that there are circumstances where there is significant justification both for saying X is the law and significant justification for saying not X is the law.
Yes, but I think that for us to actually conclude that there is a paradox, we need more input. We need to unpack what's the purpose of the question. I mean, why are you asking what the law is? For what purpose? For strategic reasons? For planning your behavior in accordance with what you predict that the judges will do? Or because you are interested to know what your moral duties are? Because unless you have a clear definition of what's the purpose of this question, because it could have different purposes. And then if you have different purposes in mind by phrasing the same question in the same language, then I'm not completely convinced that you have a paradox, because you would be answering different questions at the same time.
I understand your point that why do H.L.A. Hart in the first chapter of the concept of law, starting off with the question, what is law? And his response is basically, why do you ask? Right? Okay, fine. And if you're telling me these are paradoxes that need not keep us awake at night, that's fine too. But I think people do ask the question, what is the constitutional status of affirmative action, race-conscious decisions in the United States? And yes, sometimes it's because I need to be advised on whether I'll be civilly liable if we use this policy rather than that policy. But sometimes they just want to know, in part because they want to know not do I have a moral obligation to obey, but what should I think of? People think differently about both the U.S., either the people who live in the United States who think differently about the U.S. legal system, the United States in general, and the U.S. Supreme Court, if they think that that Dobbs is the law of this land rather than Roe versus Wade as regards constitutional status of abortion. Even beyond the question of, do I obey, should I use civil disobedience, what is the law of this country is a significant question, and not just for abstract theorists.
Well, what is the law of this country? Yeah, I'm trying to. I'm trying.
And if that question doesn't bother you, that's fine. As I said, I'm not saying that my argument here is meant to either start or stop a revolution. It's I'm an abstract theorist, so I find this stuff fascinating, even if it doesn't feed into what I do tomorrow.
I think we have the lunch time for continuing this talk.
I'll think about this. Okay.
Yeah. So I think that Daniel has a question here, and Carlos. I have 4. Let's start with this round of Daniel.
Professor, would you be more comfortable if take one question, one answer?
Yeah.
Okay.
Or one question, 2 answers.
That's on you.
So, Professor Biggs, many thanks for your lecture today and for your paper. It was really amazing to read, and as for the other papers as well, they're all clearly written, they're all really engaging. So my question is basically a follow-up to Clarissa's points, although my thoughts are a bit murkier, so I'll try to be as brief as I can in my question. So basically, Clarissa was asking you was, well, maybe when we say that the law is something about the law is truth and not true at the same time, and then Clarissa was asking, well, maybe we're asking different questions. What is the law? Might be referring to different questions. So I'm basically going to do a follow-up to that in regards to the idea of truth. So if I understood correctly, I might be wrong, but if I understood it correctly, your paper is basically claiming that, well, at the beginning at least, truth is complicated, and truth is even more complicated in the law, and we can't really equate truth in law with this sort of the debate to having truth in correspondence theories and coherence theories. We shouldn't actually think about law in those terms. And then Clarissa's question prompted me the following reasoning. Well, actually, and let me see, and please allow me, I would like to listen more about this. Maybe the issue here is that in legal practice, in our legal form of life, we might actually be using different ideas of truth depending on what we are actually asking. So if I ask you about contract law, well, are punitive damages awarded in American contract law? Answer, no. It's an easy answer. In general, we don't have punitive damages in American contract law. So in that sense, we might be asking either a predative sense of truth. Well, and if we're actually thinking about a predative sense of truth, we're basically looking at a given state of affairs and seeing if that is likely to happen or not. And someone might ask, well, should punitive damages be awarded in contract law? Then we might be asking for a normative sense of truth, and then things will be very different, and we're probably going to look at some sort of coherence argument within that legal system. Now, if this makes sense, and I'm not sure if it makes, but if that makes sense, that would have 2 implications for your argument. The first one would be, well, that might be a way out of the paradox, because you're actually changing how we understand truth. Within the legal practice, we might have different ideas of truth within legal practice. And also, if that also makes sense, we are also rebuting the initial idea that, well, truth in law is something particular, something special, because if you're asking about the normative sense of truth, we are thinking about covering spheres or somehow, something like Dworkin. If you're asking about the predicative sense, that's a state of affairs that we are seeing if it's likely or not. So it's closer to the correspondence theory. And that would actually bring legal truth within the broader domain of truth theories in general. But I'm not sure if that makes sense. And just one final bit. And then I was trying to think, well, how can I try to organize your ideas? And one thing that occurred to me, and I'm not sure it makes sense, is the famous Wittgensteinian idea of the duck rabbit. Depending on how you look at it, it's a duck. Depending on how you look at it, and it is a rabbit. But it doesn't make sense to say that it is a duck and a rabbit at the same time, but kind of makes sense.
Thank you, as always, for your thoughtful questions. Duck Rabbit was Wednesday's lecture. I'm done with duck rabbits. No, I mean, first off, I hope I didn't give the impression that I thought that truth is this terribly complicated thing, and therefore we shouldn't be surprised when it's complicated in law. That philosophers think it's complicated, but that most of us, most of the time, for most of our mundane activities, whether as just in our daily lives or our lives as lawyers, we think that truth is a fairly straightforward thing. Now, that said, I do, I probably should have made clear, and I certainly want to make clear now, the idea that in different contexts, people are looking for different things. As I quoted Holmes before, the bad person wants to know what the courts are likely to do. In fact, you go to your client, you go to your lawyer, what you want to know is, if I do this, will I be punished, or can I if I write my will this way, will it be enforced, right? It's a prediction of what the courts will do or other legal officials will do down the road. And that's a different question that you and I might have if we're discussing contract doctrine, right? And so yes, we need to emphasize that context is important, that purpose is important, and as a certified Wittgensteinian, I believe that many questions can be dissolved, but I'm not yet convinced that this one is going away. I'm maybe you keep chipping away at me, eventually I'll give, but I'm a little stubborn. It won't happen that quickly.
Thank you, Daniel, Professor Wicks. Here was a question, and then Carlos Frederico e aqui na frente, os próximos.
Thank you, Professor Brian, for your time here. My question is actually very simple, I guess, but in the last topic of your lecture, at the conclusion, Professor, you made the statement that the law is the product of both reason and will, being will, the will of the lawmaker, and being reason, reason is legal reasoning, doctrinal reasoning. I think Professor didn't mention doctrinal reason here when you were talking, but it is in your paper. My doubt, and there is a statement here also, that we are talking about source of authorities. My question is, and I know that anyone who has a minimal knowledge of philosophy of law can answer this, but I would like to understand from your perspective exactly the reasons why I have authority source in doctrinal reason here.
I catch the last sentence.
When you say about reasoning and you're talking about special about doctrinal reasoning, I would like to understand precisely the fundamentation for that we can say that doctrinal reason has it is a source of authority in law.
So the example in the paper was when you come to the lawyer and you ask about the application of a statute, right? The statute, you know, I give an example earlier in the paper. The statute says you must have 2 witnesses for your will to be valid, right? There are lots of circumstances where the statute or the contract or the will or the trust documents are not directly on point, but the lawyer who is trained at a fine law school like this one will say, oh no, you know, this is how this sort of provision will be interpreted. That what the law is in this country or the law is in other countries is not merely the literal meaning of every word of the statute, the contract documents, the trust documents, the constitutional provisions, but also how those are applied using the doctrinal reasoning accepted in that system. The forms of analogical reasoning, the forms of how certain language is, you know, interpreted, that, narrow language is considered exceptions to general language, etc. And that's, you know, it's a form of reasoning, and most and lawyers will generally assume that the law of the land includes not only the statute but all the norms you could derive using conventional doctrinal reasoning, keeping in mind that some of those moves may be controversial. And most of us, when we practice, know the difference between, yes, that's an obvious move with which no competent lawyer would disagree, and that's a harder question of which other competent lawyers may disagree.
Thank you, Professor Biggs, for the very insightful 3 talks this week. It has been a real wonderful time to have you here debating these interesting topics. My question goes exactly, I believe, in the line of Professors Ronaldo and Clarissa. When we say that, for example, plessy both is and is not valid law, aren't we asking about 2 different senses of the question? And I will call these senses, I will qualify these senses as, for example, descriptive or pre-interpretive on one side, and prescriptive or deep interpretive in other sides. So that's the first part of the question. And then the second, you rightly say in the end of the paper that truth in law is particular. It is woven into the practice of law. So it's particular because it's not fit for the correspondence theory of truth that you rightly deny at the beginning of the paper as something that fits the law. But in social practice, in every social practice, not only law, is it really a paradox that something is current law, but it's not the best interpretation of law? Or is it only perhaps a remnant of correspondence theory of truth? So what I'm asking is, in order to consider that plessy both is and is not valid law, doesn't this affirmation has perhaps a remnant of correspondence theory of truth that you rightly deny in the beginning of the paper? Because in social practice, it's very, very common that something is established this way, but it's not right that it is this way. So we could say the best account of law is not, of course, plessy. It never was. It never was Bowers. So thank you.
Thank you. I always need to revise. If I'm giving the impression that I am rejecting correspondence theory in general, it's certainly not my intention. When I say that truth in law is distinctive and particular to the practice of law, that's what I mean, is that you know, how we talk about truth in legal matters will vary somewhat from other practices. There's a whole literature on when we can talk about truth in literature. right? You know, and Dworkin talks about this at one point. You know, if you ask the question, you know, did Hamlet really see the ghost in Shakespeare's play, right? You know, Dworkin writes about it. Andre Marmor writes about it. There's a whole literature about what truth means in fiction. Right? All I'm saying is that to some extent, there are aspects of how truth works which are distinctive to law. And I certainly don't mean to disparage correspondence theories in general or say that they are particularly inept for law. What I meant to say was sort of, let's put the philosophical debates aside, because I think I said, I don't think how you think about truth in law follows from your choice amongst correspondence, coherence, deflationary, or other theories of law. And as to your prior point, all I can say is, again, I agree that there are contexts where the paradox will be resolved by saying, you know, one's prescriptive, one's descriptive, one's about practice, and one's about, you know, respect for law or something like that. I'll certainly admit that. I just don't think that all of the paradoxes can be resolved this way.
Can we have one more question? Or you, Professor?
Oh, okay. I thought maybe you were done. Maybe not enough. Maybe not enough.
So thank you, Professor, for being here with us today. I think my question is more of a clarification. I was wondering whether there is a difference for you between truth and correctness. So sometimes when you were referring to Ferguson, especially, you said, well, the previous court could be mistaken about what the issue on this particular matter was, or how it was to be decided. And the idea that someone is mistaken or wrong seems to me to imply a claim to moral correctness, whether the idea of truth in law does not necessarily seem to me to be related to that. So I wonder whether the two concepts for you are not only coextensive, but also synonymous, and in that they capture the same properties. Thank you.
Thank you. So Robert Alexie has an anti-positivist theory that's built in part around the idea that law necessarily claims correctness. And when he uses the word correctness in that context, he means moral correctness, roughly speaking. When in this paper, and I thank you again for, you know, if this needs to be clarified, it's obviously the author's fault. When I talk about truth or mistakes or correctness, no moral connotations. I mean, obviously, you know, Plessy is a fine example because, as I said, everyone hates Plessy, and everyone hates Plessy today in part because it's it's not just a wrong understanding of the 14th Amendment, it's a deeply immoral decision, right? And so everyone can reject it. And, you know, which creates an interesting contrast with Roe versus Wade is against Dobbs, as I said, because today people disagree not only about whether it's what's the best understanding of a particular provision of the U.S. Constitution, but their conclusion is often driven primarily by their view of the morality or policy of the access to abortion. But when I'm talking about truth in this paper, I mean it not in a sense of morally good. And mistaken in this paper doesn't go to the sense of morally wrong. It means as an interpretation of the text. Now, you know, this brackets off the question of you know, what role morality should play in figuring out you know, the proper understanding of the 14th Amendment, and for Dworkinians, of course, is very significant. But even a Dworkinian does not equate, you know, everything that's morally right is legally required. Right? So when I'm talking about truth and correctness, it means as an interpretation of law given by, you know, in taking into account whatever standards should be used to interpret the law.
Professor Ronaldo likes to make a comment.
Yeah, just a very, very brief comment. Reading your paper and also listening all the discussion, it seemed to me, if I understand you correctly, that you are adopting, when you ask this question and when you make the statement that let's see, it's law and it's not law as the slogan of your argument, that you in a way are assuming a legal dogmatic conception of law, which is what you sometimes call this the ordinary understanding or the mundane use of language. Conventional, yeah, conventional in the sense of, I mean, if I ask a legal, a special jurist who has written a book on legal dogmatics, is this law? It's not law. He will be a very, very attentive to what the Supreme Court has decided, because if the Supreme Court has changed its mind, he'll have to correct his book about what is the correct answer. If he's making like here in Brazil, we have public contest to be a judge or a prosecutor. So if the Supreme Court changes its mind on one topic, the board make the examination, they will have to revise the questions and the answers. So this is what we now call conventional. We usually call this legal dogmatic. Doctrinal means the same in Portuguese. Yeah, but doctrine, I think, has a different meaning in English. I don't know. I'm not sure. But here, doctrine has a clear meaning of legal dogmatics in the sense of what is written by the manuals, etc. So if you adopt this, maybe your argument will be more persuasive that there is no things can be and cannot be law. But in a way, doesn't it simplifies too much? I mean, this approach, this starting point, this point of view from legal dogmatics, isn't it this, in a way, very too shallow for raising this kind of questions? Because this concept is very much embedded in a lot of confusions, very useful strategic confusions and simplifications, as for example, a legal dogmatic book on criminal law is basically about statutes. It's not, sometimes, okay, in the very introduction, the book could say something about principles of criminal law, and he could say that, oh, we cannot reduce criminal law only to criminal codes. However, this is usually what is basically it is about. I mean, it's about what is written in the legislation. So in this sense, isn't it too reductionist for the kind of questions that you raised? It's a provocation.
The provocative is to, first be not Wittgensteinian enough and then to be too simple. I leave it to my interlocutors if my ideas are too simple. Though I'm a Wittgensteinian, I'm also sympathetic to the American legal realists, and I do focus on, legislation as interpreted by courts and as enforced by judges, because, and I have written works, one that came out last year on dogmatics or legal science, or however you want to do it, and contract law. And I think, I do teach jurisprudence, but I also teach, non-theoretical topics. And I think my job as a law professor is first and foremost, as Holmes would say, to tell the students what the courts are likely to do in fact, rather than to start with, as Holmes says, abstract axioms of reason. So maybe, if I'm the heretic, then I'm the heretic.
So I think that's enough legal theory for the day. I want to thank everyone for Professor Vix. That is already his third lecture in the week. So I want to thank everybody that participated on the audience, in person, on YouTube, and the commentators who presented today, Professor Ronaldo, Professor Clarissa, but everybody that participated. And a special thanks to you, Professor Biggs, for spending so much time and energy here with us this week into debates and discussions. It was a really pleasant...
commentators.
It was a really pleasant intellectual experience, and I have learned a lot from you. Thank you very much. And I hope that you can come again to Brazil sometime. Thank you.
For all of your patience and indulgence.